please the court, my name is Krista Dodson, and I represent the plaintiff in this action, Ms. Leanne Boyle. Your Honors, may I reserve 1 minute of rebuttal time? Thank you. This case is about a loving mother, Leanne Boyle, who was arrested for indecent exposure by Officer Brown simply because she engaged in the very necessary act of providing nourishment for her 3-month-old infant. Therefore, Ms. Boyle was falsely imprisoned by the defendants because in breastfeeding her child, she did not violate the West Virginia indecent exposure statute. Thus, her detention was unlawful. Accordingly, she moves for summary.
Could you define false imprisonment?
Yes. According to Rife v. Armstrong, false imprisonment requires a detention which is unlawful. Ms. Boyle moves for summary judgment on the case because case law supports that plain meaning is accorded to unambiguous statutes, and because public policy supports the current trend toward providing statutory protection for nursing mothers' rights. And finally,
Are there any West Virginia cases on breastfeeding and indecent exposure?
No, there aren't. However, New Jersey, did address the issue of breast exposure. However, in New Jersey versus Capetta. However, that case was distinguishable because there were vastly different facts and circumstances surrounding the incident. In Capetta, the defendant exposed her breasts at her place of employment in order to obtain tips from customers. In the case at hand, Ms. Boyle exposed her breasts merely for the purpose of providing nourishment for her child. The West Virginia indecent exposure statute is unambiguous and therefore should be accorded plain meaning.
So what is your best authority for whether breasts are sex organs or aren't sex organs?
The plain meaning of the statute requires the intentional exposure of sex organs or anus, and in West Virginia, a breast should not be considered a sex organ because the term was not specifically outlined in the phraseology of the statute. Therefore, it's unlikely that the legislature intended for the breast, the prevention of breast exposure during breastfeeding under the indecent exposure statute of this state. Additionally,
Excuse me, Counselor. What about the argument on the other side that we would be creating a very uncomfortable situation for police officers who just need to be carrying out their duties? And in this situation, there was a big uproar, and what was he supposed to do?
well, it is important for police officers to have the ability to police individuals. However, in this case, Ms. Boyle was providing necessary nourishment for her child. She had no lewd intentions or anything like that. She was simply just trying to provide for her child in the best way that she knew how. Public policy also supports providing statutory protection for nursing.
What is the current trend in other states regarding breastfeeding?
That's a good question. The trend in the law is that many states, 37 as a matter of fact, have provided breastfeeding legislation to support a nursing mother's right to breastfeed her child in public.
Ms. Dodson, don't you think the fact that West Virginia is in the minority, 13 states, is evidence that they intentionally did not want to pass this legislation?
Not necessarily. There's currently new legislation being considered. It's House Bill number 2450, the Child's Right to Nurse Act. And this act has already passed the House of Delegates with only 4 members opposed and has moved on for Senate review. The new act would guarantee a woman's rights to breastfeed her child in public in West Virginia. Yet while most states are affording protection to nursing mothers, the defendants subjected Ms. Boyle to the embarrassment of arrest for nourishing her child.
Why should this court step in if the legislature is apparently, if this issue is apparently on the legislature's plate and is seemingly taking care of it? Why should this court step in and seemingly act as a legislature in place of what's already, of our elected representatives?
The court needs to step in here because it's important to ensure that we don't, may I have 1 minute to conclude, please?
Yes.
It's important that we assure other mothers in the state of their right to nurse their child and care for their child in the best manner that they know how. Thank you.
Thank you.
May it please the court, my name is Rachel Pender. I represent the defendants, Officer Daniel X. Brown and his employer, the City of Morgantown. I will refer to both defendants collectively as Officer Brown. At this time, I would like to ask to reserve 1 minute for rebuttal. Thank you. It is agreed that there are no genuine issues of material fact in this case. We are therefore here today to ask this court to grant summary judgment in favor of Officer Brown for the simple fact that both case law and public policy support the interpretation that a breast is a sex organ under the West Virginia Indecent Exposure Statute.
Ms. Bender,
Yes.
could you define sex organ, please?
West Virginia's Indecent Exposure Statute does not explicitly define the term sex organs, but case law naming canons of construction supports the interpretation that the legislature intended the term to include breasts. Well established is the canon of construction set forth in Smith versus State Workmen's Compensation Commissioner that where a statute's meaning is uncertain, the contemporaneous construction given to the statute by those charged with its enforcement must be given, quote, great weight. This construction will not be disregarded or overthrown unless it is clear that the construction is erroneous. Here, Officer Brown, a government officer charged with the execution of the Indecent Exposure Statute, clearly construed the term sex organs to include breasts. Otherwise, he would not have arrested the plaintiff after she intentionally exposed her breast at a public pool. According to Smith, the court should thus give great weight to Officer Brown's construction of the statute and conclude that breasts are sex organs as a matter of law. In addition to canons of construction, other case law supports the interpretation of sex organs including breasts. Courts in other jurisdictions with similar statutes have determined that exposure of breasts falls under their equivalent of an indecent exposure statute.
But do those other states have breastfeeding exemptions?
The particular case that I'm going to mention does not have an exemption, I don't believe. The case I would like to bring up is State versus Capetta, that raised by my friend, the plaintiff's counsel. In Capetta, the defendant performed a dance routine in which she removed her top and exposed both of her breasts. Subsequently, she was charged with New Jersey's equivalent of the indecent exposure statute.
Counselor, wouldn't it be prudent for this court to draw a line between a breast being exposed for the case in Capetta and a breast simply being exposed to breastfeed a child? Wouldn't that be a logical line to draw?
The defense certainly supports breastfeeding. It's an act that's beneficial to the mother and child. We're not here to argue that breastfeeding is unlawful. We're simply going off the facts of the innocent case. The plaintiff removed her top completely and exposed both of her breasts. A lifeguard had asked her to cover up and she refused to do so. Mrs. Purdette had asked her to cover up as well, and she did not. Mrs. Purdette's young son cried after seeing the plaintiff exposed. The issue is not breastfeeding. The issue is the officer's interpretation of the statute and whether or not sex organs includes breasts.
Did he see her breastfeeding? He knew she was breastfeeding?
The officer?
Yes.
When Officer Brown was called, he arrived at the pool, and as I recall, she was still exposed.
Can you refute your opposition's contention that an officer should act as an interpretation of the legislature?
That is actually the point I would like to express, that West Virginia canons of construction support the fact that an officer's construction of the statute should be given great weight in a court in interpreting that term.
Ms. Bender, what about the canon of construction that says that penal statutes should be construed narrowly in favor of Ms. Boyle?
That is certainly a canon of construction, but regarding these facts, other canons of construction are certainly applicable as well. The great weight of authority certainly would agree with that canon, but other canons of construction, such as the officer's interpretation, and one I'm about to mention, would certainly be more applicable in this case. My friend mentioned that many states, 37 to be exact, have recently passed legislation that making breastfeeding an exception, that makes breast exposure an exception to indecent exposure. However, it is important to note that West Virginia has not passed such legislation, indicating that the intent of the legislature was not to allow breastfeeding as an exception to the statute. It is a commonly accepted principle that where the legislature has made no exception to the positive terms of a statute, the presumption is that it intended to make none. So the West Virginia legislature likely did not intend to allow breastfeeding as an exception to the indecent exposure statute. May I have a second to conclude? In conclusion, because canons of construction promulgated by state law, foreign case law, and public policy support the argument, the court should determine that, as a matter of law, a breast is a sex organ under West Virginia's indecent exposure statute, and therefore grant Officer Brown summary judgment.
Thank you.
This case is about a mother who was trying to care for her child, and in doing so, decided to breastfeed her child, which is recognized to have many benefits for both the mother and the child. There is a growing national concern for the well-being of infants and the support of nursing mothers, to such an extent that 37 states have enacted statutory provisions for their protection. West Virginia should and likely will follow suit with the new legislation which has been proposed. Therefore, Ms. Boyle's arrest was unreasonable, and the plaintiff asks for summary judgment, determining as a matter of law that she was falsely imprisoned by the defendants and seeks relief in the form of damages. Thank you.
I would like to address two issues raised by plaintiff's counsel. First, as Ms. Dodson mentioned, the plain meaning of a statute is adopted only when a statute is unambiguous, according to the Crockett case. According to Dunlap versus Freedmen's Incorporated, an ambiguity does not exist in statutory language which laymen are readily able to comprehend. Here, the procedural posture of the case indicates that the statute is ambiguous. We are here today because a law enforcement officer and a layperson, the plaintiff, disagree as to the meaning of the term sex organs in the indecent exposure statute. This difference of interpretation shows that the statute is ambiguous. Thus, the plain meaning rule does not apply in this case. The Child Right to Nurse Bill, House Bill 2450, is recently in the Senate for vote. The fact that such a bill exists further supports the argument that the legislature intended breast exposure to fall under the indecent exposure statute. If breastfeeding were already an exception to the statute, there would be no need for the proposed legislation. Thus, because applicable canons of construction, foreign case law, and public policy support the argument, the court should determine that as a matter of law, a breast is a sex organ under West Virginia's indecent exposure statute. Thank you.